We'll go to a 4-minute round, starting with Mr. O'Toole.
Thank you, Mr. Chair, and thank you, Mr. Côté, for your service, including, as I learned tonight, as a JAG officer.
Indeed.
So, I'm going to suggest to you a better analogy than the Competition Bureau, because your presentation reminded me a lot of law school over a decade ago and some work I did, particularly because you described yourself as the enforcer of the legislation. That was a line you used. A better comparator would actually be securities commissions, because they are commissions that regulate and administer in the public interest, securities, and confidence in the public markets are critical. In the last 15 years, there's been a move away from Securities Commission with a commissioner in a very similar structure, from also being multifunctional agencies with investigative prosecution and even adjudicative functions, which would be similar in some ways. In fact, in 2003, Justice Coulter Osborne had what was called the Fairness Committee about bifurcating the OSC, much like the BC Securities Commission did. The reason I use that is because it's clear to me that since the creation in 1974, where you said the chief electoral officers had some concerns about this being housed within the agency, through to the splitting off of the prosecution mandate to the DPP in 2006, is C-23 not really the completion of that bifurcation, so that we have Elections Canada running something in the public interest, in the public good, from an administrative standpoint, and to respect all principles of natural justice, the backward-looking functions, the investigation and prosecution, is housed entirely distinct. Now, not just the prosecution, but also the investigation in the DPP. Is it not just the completion of that bifurcation, and is that not in line with modern public administration practices?
Well, I would go back, I think, Mr. Chair, to some of the points I made in my opening remarks. One is that we have in Canada at least 5 provinces that have maintained that have in place, I should say, the system that we have been proposing, and I'm referring in particular to Ontario, Quebec, Manitoba, Alberta. I would also point out that the Australian Electoral Commission has that power in the same way that the U.S. Federal Elections Commission has the same power. That's point number one. I would also point out, as I said in my opening remarks, that we have within the federal government agencies such as the Competition Act, but also Fisheries and Oceans. We have the Canada Border and Security Agency. We have the Canada Revenue Agency, where we still have the thing that...
If I may, because I don't have much time, I use the Securities Commission example because of the regulatory overhaul in the last 15 years, and because I think it serves very similar purposes of the public interest. And I sprung this on you now, so feel free to provide the committee your comments afterwards. But do you not see the benefit from a public confidence standpoint of having that administrative function housed in one distinct administrative body, Elections Canada, and your function, the investigative aspect, housed separately, much like the Securities Commissions have done?
I don't, and I don't for at least, well, a number of reasons, but the main ones would be that if this issue of the independence of the Commissioner is a real concern, it could be addressed by way of amendments to the Canada Elections Act.
I didn't mention that as a concern. I'm saying as a principle of public administration. That's what a lot have been doing. Even
as a principle of administration, as you say, I think the Canada Elections Act could be made clear that the Commissioner, you know, whatever it is that would be required to state black on white that he is to exercise his functions in a way that is completely independent and so on. But the other thing is also the loss of efficiency that would necessarily flow, in my view, from us being taken out of Elections Canada and moved into a department of the government. And that's a real issue at a time when we are challenged to be more timely in our investigations and come to conclusions more quickly. Anytime you put distance and you build or allow barriers to be built in terms of exchange of information and communication.
But isn't distance what I'm getting at? Isn't that separation of the two functions important from a public confidence standpoint?
Probably a very good question, Mr. O'Toole, but I'm going to move on to the next person. Madame Latendresse for 4 minutes.
Merci beaucoup, Monsieur le Président. Merci, Monsieur Côté, pour votre témoignage.
Thank you very much, Mr. Chairman. Thank you very much, Mr. Côté, for your presentation. I'd like to ask a few questions on 510.1, which will limit what you may communicate or divulge. I think what it says is that you have to maintain secrecy on all that goes on within your office, generally speaking, with a list of certain exceptions. B, for example, information which are required to conduct an investigation. This exception then, information that would be required to conduct an inquiry, investigation, these things may be communicated. Now, do you think that insofar as once an investigation is completed, do you still maintain that right to communicate that information? I think I mentioned in my preliminary remarks that the way I interpret the provisions here and the legal advice that we received on this matter, that 510.1, certain serious issues arise from that. After an investigation is complete, I don't think I would ever say anything other than the investigation is over and we decided to take no action or this action. As you know, in Canada there's a lot of media coverage when an inquiry or investigation is underway, and people want to know what we've discovered and why we arrived at conclusions we arrived at. But if I take a look at 510.1, the way it is written now, we arrive at the conclusion that our capacity to present a report, for example, would be extremely limited or non-existent. Would you suggest modifying this? Absolutely, absolutely. Thank you. My next question concerns the fact that currently, for the appointment of the next commissioner of federal elections, there won't be any consultation on who might be, well, that's what I see in the bill. What do you think of that? Well, I don't think it's my place to make a comment on that one way or another. I find it rather peculiar. I don't see why you would actually put such a just a provision in the law itself. Other people are better placed to answer that question than you, but I was surprised that such a provision would even be introduced. All employees having previously worked in Elections Canada may not be appointed as commissioner. Isn't that a bit strange in itself? It seems that there's a rather severe insistence that, not come from Elections Canada. Well, it raises some serious questions. Thank you. Could you speak to us generally of the consultation that might have occurred was your office consulted? Were you consulted as to any of these changes? Well, Mr. Chairman, I replied to this question earlier, and I will repeat what I said then. Nor myself nor my office was consulted by the Minister on the various provisions of this bill. And the fact that the recommendations of the CEO and yourself have made in the past, were some of these recommendations incorporated into this bill? Well, generally speaking, the Director General, the Chief Electoral Officer, indicated what was included, positive elements, the increase of fines, for example, the creation of new offenses for individuals who would obstruct any investigation or inquiry underway. That's all very positive. The new offense of impersonation, passing yourself off as someone else, that amendment is very welcome. I also said in my preliminary remarks that we propose introducing into the law a sanction, administrative sanction, reimbursement of electoral expenses might be reduced if somebody overspent at any given time. And I think that's a step in the right direction. That would be quite useful. I think we should have a number more of these types of changes. There are so many offences in the Canada Elections Act. You know, the thing is about 3 inches thick, but regulation. For someone who wants to respect the Canadian justice system, I don't think that the only tool that we should have should be criminal, a criminal case, a criminal charge, if you will. We should do something other than use the criminal law to try to correct or amend or improve the system. And perhaps more pertinent, depending on the allegations that are brought or the charges that are being considered.
Surround. 4 minutes, please.
Thank you, Mr. Chair. I've been on this committee for over a decade. We get regular reports from the Chief Electoral Officer. The Commissioner of Elections tends to come here less frequently. So I'm just wondering, just in terms of how you report, do you publish any independent reports similar to the ones that the CEO publishes, describing your activities for the past year, what you've been doing? Is anything like that done by you?
In last September, I issued an annual report, which was the first report issued by the Office of the Commissioner. And that report is out there. It described our activities and our work, and also it contained a certain number of recommendations about challenges that we were facing, and our recommending to the government some of the changes that should be made to allow us to deal more effectively with those challenges.
So you published that last September. That was the that was the first time an annual report had been put out, but it's your intention to do this on an annual basis from now on?
It certainly is my intention. In that respect, I would note, Mr. Chair, that the bill, as it currently reads, now provides that it is not the Commissioner anymore who would be reporting on his activities, but it is rather the Director of Public Prosecutions that would report on the activities of the Commissioner, except for the specifics of investigations, as the bill says, and I think that this is regrettable. I think that the Commissioner of Canada Elections, wherever he sits or they sit in the organization, should have the ability to make their own report about their activities without any kind of filter anywhere.
So let's see if I understand this right. As it stands now, the Canada Elections Act does not mandate that you produce a report. It's your own initiative, but it doesn't forbid you from doing the report. The new legislation would actually prevent the kind of report you issued last September. Is that correct?
The provision in the bill specifies that it is the Director of Public Prosecutions who would report to the Attorney General about the activities of the Commissioner. Yes.
Is there anything that would make it impossible, in your mind, to amend the bill to permit you to report directly to this committee?
I don't know in terms of machinery of government and parliamentary procedure whether I should be reporting to this committee or to Parliament, but certainly it seems to me that nothing would prevent this committee or Parliament from amending the bill and making it clear that the Commissioner has the ability himself, herself, to make report on his activities, and whether it goes to this committee or to Parliament at large or to the both houses of Parliament is an issue that...
Well, I can give you my own opinion, which is you should be reporting not to any other committee but to this committee, and the reason is that we deal with all elections matters. It makes sense to have the same committee overseeing these things. The analogy I've given in previous hearings is to a board of directors. You want all management. If your company has multiple divisions, you want all management to be reporting to the same board of directors. But that's a very interesting piece of information.
But the analogy that I would make, Mr. Chair, would be that my understanding is that the Chief Electoral Officer reports to the two houses of Parliament. So given that, there is some elements of commonality between the two, an amendment could provide also that the report of the Commissioner would be like the reports of an agent of Parliament and go directly to the two houses of Parliament.
All right. That's very helpful. Thank you very much.
Okay, great. Then we have completed, and we thank you, Mr. Côté, for coming tonight and sharing your information with us, and thank you.
The members of this committee for having taken the time to hear from me. Thank you very much.
Great. Thank you. We will suspend just for a couple of minutes while we change witnesses.